For admission, item numbers 1 to 8.
Yes, Mr.
I was my mother, my senior friend, so which is commission. I began my place first. So when I was yesterday, I was informed by my juniors that we are watching as to how these universities will have the extension counters had permission from the NCTE. There was a specific way put to them. Now my knowledge, we have a very peculiar system of functioning in the state government. If my knowledge, bear with me, just give me a minute. Because your option is very puts a different spin to the entire case.
My iPad. I need that.
A spin which was not contemplated during the disciplinary proceeding.
No, because see, disciplinary proceedings, they will come up with an argument of an empty formality theory. So we will not go into that. We are on the issue.
Yes.
Now, it is an admitted position that you had to take this degree to continue with your job. Now, the question is whether the degree or diploma, whatever it is, you have pursued, have you pursued it in accordance with the law?
Yes.
1. 2, that law would be the law laid down by UGC because it concerns a university.
Yes.
Now, B.Ed comes, it is again a subject under the NCT.
Yes.
Now, if you had done it from a university within the state, then it would be a different situation altogether. Now, this universities that are here, what I have seen is 6 universities, the 6 appeals. University is one, that is Janardhan Rai University in Rajasthan. Now, it's a settled position of law that Janardhan Rai, they cannot go beyond the territory. For that, they will have to have from the earlier DEC, Distance Education Council, which was an amalgamation of UGC and other, they'll have to have a permission which is not available. Secondly, the most damaging thing is they have come up and filed an affidavit saying that these are not our students. And that has been duly noticed by the
In the writ proceeding,
writ proceedings.
not before the.
No, in the writ proceedings. So now what has happened here is you may have been taken for a ride by the institute in Dimapur, wherein you got yourself registered.
Yes, sir.
That's a different aspect. You can always proceed against them. But the degree that you obtain is not proper. That's the context we are.
Therefore, the difference between now I want to introduce.
You have to take us out of this.
So on that basis, on the premise issue, what should I put forward? The point is, are the petitioners to blame? Why am I making this specific point, Your Lordship? There is a practice, Your Lordships. Like I was saying before, there are peculiar practices which state has adopted. The first order, this is something now, right? This is an order dated 2nd September 2008. The following unmentioned candidates, this is by the government of Nagaland. The following unmentioned candidates are hereby permitted to undertake BEd course to correspondence under different universities without disturbing their daily normal duties. And what are the lists for universities? Again, Your Lordship will see. So everything was done with the permission of the government.
Now, is this pertaining to the appellant herein?
So from 2000, after a certain period of time, of course.
No, these are not the appellants.
No, these are not different. But
There
this
is-
practice which are.
No, there is no order allowing the appellants to undertake this course.
Because that practice was discontinued.
It has to be.
And that practice was discontinued, and the only condition was that when we take the BA course, we inform the authority.
See, you taking a course with IGNOU is a different thing altogether. IGNOU has a reach everywhere.
Yes.
Now, why I'm telling you, this is a problem not only which we face in this bench. We face this problem in Gauhati also.
Yes, ma'am.
Now, you have a university here called the Nagaland Global. Global Open University. Now, Global Open University doing a degree somewhere in the bordering district of Nagaland, I may have to understand. But a student sitting in Nalbari, which is
Possible.
across the border, he doing a degree in that
No
connection.
problem for that.
So that's the same thing. Reverse you play.
That is why I know. When the commission was drafted by are the employees at fault?
Okay,
And
accept.
then your lordship could see, it's not just ignoring. Yes, the BSP Lucknow and South Christian College, of course, then the other, in the other orders also. A whole list of other universities. Then
This practice was subsequently
stopped. And the only requirement was that when a teacher joined one of these BA courses, he supplied the information to the authority. That is all. Now, my lord, if I may seek your lordship's indulgence, there is a possibility that this case may traverse beyond this court. Now, I wish to place all this by way of investigator on record. It is not my fault. It is not the petitioner's fault what has happened. So give me some time to place these facts on record.
That's the beauty of a council. You have tied us down. I really appreciate that. Anything we need to do?
My lord, 4 weeks time, we'll exchange affidavits in the meantime.
Today, Mr. Zamir is also having a similar issue in another matter with regard to CMJ.
Yes. And your lordship's aware the CMJ went up to the Honorable Supreme Court, and there the discretion was given to the appellants, the teachers, to file a representation before the government.
But in the state, I think they have allowed it till 2014.
CMJ NCT or something.
NCT did not allow.
The BEd or the DLEd
Was not allowed.
they are not other courses which do not require either the NCT, AICT, Medical Council.
They were allowed.
They would be degrees issued by the university, but not recognized for any valid purpose. You would have a degree which has got no recognition.
No recognition for the purpose of your
Government servant or promotions.
Yes, what do you say?
With due respect to my elder senior friend here, even if they file affidavit also, or if they even if they bring new reports also, how is it going to change the fact that they have submitted a fact document before the department? When the university itself has, in the form of an affidavit, admitted that they were not experienced. Not only that, Your Lordship, they have not replied to that affidavit of the university concerned, which clearly shows that they have admitted the fact, Your Lordship. So even if affidavit is filed, Your Lordship, how is it going to change that fact, Your Lordship? Now, why was short cause notice issued, Your Lordship? Why was memorandum issued? Why was articles of charges framed against them? Is it not because of submission of a fact document, Your Lordship? So these facts, these facts cannot be changed by filing
if you come down to that,
yes,
cursory, what we could peruse. Before the disciplinary authority, the university was not there.
The letter of the university was there.
Produced it in the inquiry. Was it proved in the inquiry?
Your Lordship, the letter of the university, we have on streamlining it, we have sent the certificates to the university concerned. The university concerned has submitted a letter to us stating that it is fact.
6 candidates were there from that Rajasthan University.
All the appellants here in
6 appellants.
yes.
The other 2 one is from Dibrugarh, the other one is from some other university.
Yes.
Appointment was in pursuance to a selection process. You don't dispute that.
Your Lordship, the initial appointment was on ad hoc basis, not on the selection process, but on an ad hoc basis. It was not pursuant to any advertisement. Subsequently, they were regularized.
Why did you give them a regular thing subsequently?
Yes, subsequently they were regularized, Your Lordship. Yes.
Where are the regularization orders?
Your Lordship, the regularization order will find it, Your Lordship will find it at page 54 of the petition, Your Lordship. Page 54, madam. Your Lordship may kindly also peruse the serial number 6 where there are 7 conditions prescribed, Your Lordship. Your Lordship may kindly peruse the serial number 6, madam.
Assuming.
Yes,
Our sympathies are with these people because they were working for such a long time.
yes, madam.
Now, my fear, we were just having a talk on that also. Now, we undo this thing.
Madam.
Okay, what has happened has happened. You have been regularized in pursuance to a recommendation of the interview committee. Now, we have a suspicion whether you can pursue a DLED course, because to pursue a DLED course, you must have a certain percentage of marks
Yes.
in the higher secondary examinations. We had also said you have to have, whether you have that or not would be an issue.
Your Lordship, that aspect is also taken care of by the notification of 116, which is at page 60. Page 60. Page 61.
No, clause 1.
Clause 4.
Clause
Clause
4.
4. If an untrained teacher does not acquire the prescribed professional qualification within 5 years from the date of publication of this work, his or her further increments of pay shall be stopped.
But you
And
did
he
not
or she-
argue on those lines.
So,
You have not argued in the before the single judge on those lines.
no, Your Lordship. But firstly, my lord, in the appeal, Your Lordship can well take this factor into consideration.
No, why should we? Give me a good reason for that. Because see, you have not projected in the petition that you were all taken for a right by the institutes. That was a valid argument you could have made. That we did not know. We did not know. So we got ourselves enrolled there, as was the practice followed. And because of that, we not there. So the sport you could have prayed. That part you hive it off.
Your
You
Lordship,
hive it off, that part we hived off. And let us continue in terms of hope and give us an opportunity to pursue the matter. Take our time, friend. It's easy to dismiss this. But human consideration is also there.
Your Lordship, if Your Lordship will see the introduction of this notification, there are 11,982 untrained teachers. Oh, the large majority,
No, this is not for you. This is for
in fact, Your Lordship, in
When were you regularized, most of you?
2000,
2005.
yes, ma'am.
12, 12.
12.
12.
2012.
12. This regularization is there.
No. That is so. There was this notification from the central government that those who were appointed prior to a certain date, or regularized prior to that, they were not required to get.
Yes. Well, Lordship.
They were
That
not
is
required
under the Act of 2001. But here, that is yes,
the requirement of 2009.
yes,
The requirement under the RT 2000, NCT got the authority.
Do you have the RTI?
NCT got the authority
Right to education.
to lay down these conditions by the 2009 Act.
yes, correct.
2010, NCT had given the notification that these are the norms to be followed,
Yes,
saying that persons who were appointed prior to that notification
correct.
would not be required to have B.Ed or D.El.Ed.
Yes,
If I'm
but
not wrong. So these persons were appointed to government service on whatever basis prior to that.
yes, but Your Lordship,
So they did not-
there is a condition. They have to fulfill the norm that has been laid down in the Act of 2001.
The notification prior to 2010, whatever was prevalent.
Yes,
Did it require D.El.Ed?
yes, Your Lordship. I have to be Your Lordship. I will tell you.
Show me.
That's it. I got it. Your Lordship, the English part starts from page 6, Your Lordship.
When were they appointed?
2005, but regularized on 2012, Your Lordship. So the notification 2010 applies to them, Your Lordship.
And they were appointed in what primary schools?
Yes, yes. Primary teachers.
Primary also. তাতো D.El.Ed primary D.El.Ed লাগিব।
So the qualifications, Your Lordship, as per this Act 2000 notification 2001.
There was another notification in the after 2001. The next notification was in the year 2010.
Yes,
Yes.
yes, Your Lordship.
When were the dates of appointment?
2005, Your Lordship.
What is the date?
Your Lordship, the petitioner in the first appeal, Your Lordship, were 2005, my Lord. Yes, date is 23/3/2005. But this is purely on ad hoc basis, my Lord.
Do you have the 2010 notification?
Yes, my Lord, I have.
Let me go on.
The thing which the Lordship was including is on the last page, Your Lordship. 4.
That is 2001. তার পিছর কথা আছে।
2010.
Kindly come to page 7.
Yes, my lord.
Teachers appointed before the date of this notification.
Yes,
Teacher appointed on or after the 3rd September.
yes.
Is not required to acquire the minimum qualification.
Your lordship, then no, it says, your lordship, if I may be allowed to.
No, please,
read
please, we are trying to understand.
4A,
Ah,
the teachers appointed on or after 3rd of September 2001. On or after?
they were appointed.
On 2005.
So on or after.
On or after.
So are not required to.
See, your lordship, the date on which the NC Dissemination Regulation Act as amended come into force in accordance with that regulation. The regulation which I have placed it earlier, your lordship. So that regulation 2001 will apply. You know.
On your lordship's query about taking the ground of being victimized in writ petition, you should find it in page 42.
Just passing remark.
Okay. But just to satisfy your lordship on that point too.
No, what you have taken. Page 42.
Page 42. 11 paragraphs 11 and 12. I even filed an FIR on it.
Oh, that is against that incident, but you did not press that.
In paragraph 12, I have mentioned my lord.
Victimized by the university. The university had never victimized you. The victimization is by the
Extension control.
the only thing which is.
It was something which was not connected with the university at all.
That is what they say, man. That is what they say in the letter which was written to the inquiry.
No, it cannot be because that UGC does not permit that. University would be in trouble.
But all that, my lord, is subject to evidence. And there was no evidence as far as the inquiry committee is concerned.
Mr. Zumi,
My lord.
the materials that are on record, we don't find any error with the conclusions drawn by the learned single judge. But considering the fact that the persons have been working from 2005, teaching students, now those students may have also reached some places. So that's what is holding us back. Mr. Zumi, there is no stay order.
There is
a stay order.
There is.
They're continuing.
No, your lordship,
Terminated. German was said, but consequence that they are
Already out.
already out.
Yeah.
They are not in service now.
No, then.
Okay. But Mr. Zami, you're also there.
My case and the present cases will have a slight distinction.
You are in item number?
Item number 2, Lord.
Okay, what is the distinction?
Distinction is that we are primary teachers, whereas I am graduate teacher.
B.Ed.
BA,
And you took your B.Ed from
Debrugge University.
Dibrugarh University, and they have denied that.
The types of qualifications.
Hmm.
One is clerkships, basics, and the other is additional qualification. And
Professional qualification, they call it.
we are more under additional qualification. And when we had a learned single judge finding, he arrived to a finding that the petitioners do not have the basic qualification.
That fine, but what about your professional qualification? That's what was in your regularization.
English, the program I have enrolled. I have met in undertaking at the time of appointment because on the basis of.
Again, you did not go to Dibrugarh, you did it here only.
Because it is correspondence course and that was allowed specifically in that manner.
No,
So I enrolled.
Mr. Zamir, that's a different thing. You had a system in place. But thing is, Dibrugarh University cannot offer that course to you in Nagaland.
That is the condition what.
And Dibrugarh University has filed an affidavit in the writ petition saying, denying that you are not given.
It is not possible.
No, they say that you are not a student of Dibrugarh University.
Enrolled in that.
Fine.
So I enrolled.
The materials on record, the conclusions of the learned single judge with basing on the affidavit filed by the Dibrugarh University, para 19, I suppose, 17 or 19.
17, 18, 19, the
No.
single judge has arrived to the conclusion basing on the additional
Affidavit.
qualification.
No.
And it appears.
No, the qualification that was requisite to be completed by you is a B.Ed degree. And para 17, it says that your writ petition was never pursued from the Dibrugarh University.
We are saying that the Dibrugarh University do not have the territorial jurisdiction
No,
to offer.
that I would have,
Jurisdiction.
no, that I would have understood. But the contention of the Dibrugarh University is, in addition to what you said, is that these were never our students. The affidavit is very clear. The affidavit is on record. If we proceed on that lines, we will be left with no other alternative but to dismiss the appeals. I think you make a course change.
Maybe a victim of the fraud.
That is what you got to bring on record.
I may be a victim of the fraud played by somebody else. But so far as I am concerned, government has approved to undergo training.
Mr. Zamir, if your argument was that, see, we were working from 2005, you.
No, Lordship, I am appointed only in 2013
Fine.
on the basis of an advertisement.
Okay. 13, whatever it is, you were in pursuance to a selection process, you had come in, or Mr. Zibomi's thing, 5, they were working subject to a process of recruitment, come in, utilize that 2016 notification clause 4, say, fine, we were victimized. We did not know because this was the practice that was being followed in the state. We also just jumped into the river through its flow. So now give us an opportunity. Come again with that.
Secondly, if at all you want to penalize me, you follow the law in accordance with.
See, that again will not be acceptable.
Lordship, one aspect. Let a single judge arrive to a finding that since the initial appointment of the petitioner is not in accordance without having the basic qualification, therefore, even if other formalities are followed or not, that is an empty formality.
Okay.
So by relying on the principle of empty formality principle, this case was decided. Whereas the principle of empty formality, lordships are well aware that is applicable in a situation where the initial appointment itself is illegal, number one. Number two, the appointment was made without possessing the basic qualification. That is why I am trying to make a distinction between the basic qualification and additional qualification.
Mr. Zamir.
And I am willing to undergo the training.
But Mr. Zamir,
Lordships.
that argument will not hold water now after the decisions of the Supreme Court, the NCT guidelines. Now, NCT guidelines cannot be, when we don't have a power to go beyond that. Now, NCT guidelines within that itself has both your education, if I may say, educational and professional are one now. It's not two. It's only because of a habit developed by the department and by us in the courts, we have distinguished between a basic degree and a professional qualification. Now, these two are the main ingredients which will make you eligible for appointment. It's not a case that you will be eligible only if you have the educational qualification, not the professional. I'm just using words to distinguish that. Now you say about the empty formality. We ignore we will set aside that part of the judgment. But then if we consider, again the thing will come to that only. It will only require a little recasting of the judgment, but the end result would be the same.
The D8 also, they are saying that it's not.
That was never the argument. That's what I am telling. I told Mr. Zimumio, that was never your argument. You did not press that. You went hammer and tongs with your qualification. Okay. Hmm?
The basic objections which were raised in the writ petition was also that the principles of natural justice was not followed because of the fact that we were just given the questionnaires. You replied this question and answer. That too we were allowed to submit in the counter of the department. So inquiry has not been conducted in accordance with law, and the learned single judge has categorically met that.
You are appearing as a departmental counsel or senior government advocate?
Senior government.
Heard, Mr.
My God, before that, like any others, kindly let me make one last submission. With the limited knowledge that I have, my Lord, I wanted to make this submission. In an appeal, including a single bench model, can the petitioner come with a plea that I have been victimized? And that victimization card, putting it before the appellate court, seeking some relief on that issue, Your Lordship.
This
is one thing what has to be seen to my understanding, my Lord.
Mr. Angami, your argument accepted, but the problem here is we are on an intra-court appeal. This is nothing but a continuation of the writ petition. We must not forget that. It's not an appeal, quotes, as an appeal in the civil procedure. This is an intra-court appeal.
Correct.
We are here they can take pleas here. There is no problem. Because it's an intra-court appeal. What we propose is, it's very easy for us to dismiss it. We were prepared for that also. But Mr. Zibumi, Mr. Zamir, having now developed something, we will give them an opportunity to develop it further. And thereafter, let's see how it goes about. Let them file an additional affidavit. You file a reply. They can't take a plea which was not there in the writ petition. But I find in every writ petition, that plea was there of victimization. And they are all brought in record or brought to service by you through a process of selection. Either in the initial stage or subsequently. And see, this qualification at that point of time you had condoned. They may be under pressure or by following the procedure that was there, which is totally wrong. They had done it. Now, let us see if we can mold something for them, if possible. It may not be possible. They are behind, their back is behind to the wall, guaranteed. But when they have made a prayer to senior counsels, let us give them an opportunity. It's around 8-9 lives, 8-9 families who are in, because if we allow them also, it'll be only around 9 teachers coming back, whom you found to be suitable through a process of recruitment.
Your Lordship, at that point of time, the issue of this PN or die certificate was not there, Your Lordship, during the time of appointment. Therefore, they have taken an undertaking that they will complete this course within a period of 2 years.
No, in 2012, when it was there, you could not have given that extension because that was the law on that day. You could not have given them an extension because they were, at least Mr. Jami's client was not there. He did not have a service prior to that. You could not have given them. You ought to have rejected them. You may have given it to them because in this state, you may have a dearth of teachers or persons having B.Ed degree. So these aspects, as a writ code, we may have to look into. I'm not saying that we have closed our minds. No. Let us give them an opportunity. Otherwise, I kept these matters today. We both were ready to dismiss these matters today. Because these are matters, these are matters, Mr. Angami, which we do day in and day out. These are issues in Gauhati, which we deal day in and day out. My friend was the standing council education.
Yes.
He is thorough with that. I have passed several orders dismissing similar petitions. But let us see.
Your Lordship, then ultimately the submission is on the victimization part. Your Lordship.
I'm not saying anything.
Lordship,
I'll not give them they have prayed for time to file an additional affidavit. I'm giving that time. Give you an opportunity to counter to that. That's much so. Heard Mr. City Jamil, senior counsel.
Chief has made a pointed query to my friend Zemomi that whether if an opportunity is afforded, whether you are eligible to enroll roles. So far as I'm concerned, I'm eligible.
Okay, fine. Because DLED degree requires 50%.
But
That relaxation is no longer there. Heard Mr. City Jamil, senior counsel, assisted by Mr. Aimchen and Mr. Z. Zimomi. A. Zimomi, learned counsel, appearing for the appellants in the above noted appeals. The learned also heard Mr. Mr. N. Angami, learned senior government advocate, Nagaland, appearing for the respondents in the above noted appeals. The learned counsels for the appellants have submitted that they be given an opportunity to bring on record an additional affidavit to highlight certain contentions which were raised by them in the writ petition, but were not either pressed and or not considered while considered in the impugned judgment. So, Mr. N. Angami, learned senior government advocate, has vehemently objected to the said prayer made by the petitioners and has submitted that the materials available on record would demonstrate that the petitioners have no case and the impugned judgment would not mandate an interference. Also, for the ends of justice, this court accepts the prayers made by the learned counsel for the petitioners and grants 2 weeks' time from today to file an additional affidavit. It is made clear that no further adjournment shall be granted in the matter. On filing of such affidavit by the respondents, the learned senior government advocate is given further 2 weeks' time to submit a rejoinder thereto, ipso advised.
Yeah.
Registry to list this matter again on
The end of June, bro.
let it be 17th of June. 17th is it's a working day.
Yes, working. 2 weeks so that they can give you to get it necessary. I'll try with you. Give time.
10th. Okay, 10th. 10/6/2026.
I'm deeply obliged.
This is an order by considering that we are succeeding in 226 jurisdiction, not on merits.
Deeply obliged.
Right. For orders, item number 9.
No, more to Yes, have you got something? Mr. Counsel, your death certificate is nothing. You have very good control over your diabetics. Your HbA1c is only 6. You have brought that in a report yesterday. Wait. Huh?
Page 55.
55. No, 55. Huh. 56. This is a very good control of diabetics.
Well, this was done in the month of March.
March,
Yes,
but there is no report thereafter. It's a recent report. This is a reading of 3 months of your. This is the HbA1c is the reading of your cellular, the sugar status in your cell for 3 months. It's a record of 3 months kept by your cell. It's nothing else. So it's only medication now. Your medication you can take in the jail also. Convince us.
Here, the appellant, he was on bail at the time of trial. Thereafter, after the filing of the appeal, I was filed for suspension of sentence on the ground on medical ground. I was filed on medical ground for suspension of the sentence. This court felt that instead of suspending the sentence, it is better for him to go on bail for a short period of time and do the surgery. That was allowed. Thereafter, since he was taken care from the.
You were sentenced to undergo imprisonment for 20 years.
I was for imprisonment for 38 years.
38.
Minor years. Thereafter, since he was taken care from the district hospital, he was shifted to a private hospital. And from there, the doctors, they advised him that before going for surgery, you need to stabilize all these.
Where is the initial order granted to you?
That is in page number 41, my lord. Page number 41. The relevance starts from page 42. May I read it, my lord? Here, medical board was also constituted, my lord. Okay. Before allowing him to go on bail, medical board was also constituted. It was not just decided by the court, but the medical board was constituted, and on the recommendation of the medical board, it was allowed on bail.
Has the trial court records come? Has the paper book been made? Why?
It's on process, my lord. Order has been passed, it's in process. On the last occasion, order has been passed.
So how long does it take for a paper book to be made here? 4 weeks. The order was passed in March, so it's already 2 months now. Can you just take information as to what has happened with this? Okay.
So what do you say? He has a certificate saying that it would require another month for the surgery.
Since the case.
So ball is back in our court.
You are Mr. Takakichu,
My lord, yes.
or Mr. Takakichu Leonard Council is paying for the applicant also heard the Leonard. This is an interlocutory application praying for extension of the bail granted to the petitioner by the order dated 11/3/2026.
In IA Criminal 13/2026.
in
55, 45,
violation
bottom to 41.
in IA criminal number 13 of 2026. Stop. It is the case of the applicant that the petitioner had filed the IA criminal 13 of 2026 along with
Mhm.
the criminal appeal jail
No,
number 12 of 2025.
no, page 41 first. He had filed the first application on page 41, first application.
You say you don't say criminal appeal 12, you say criminal appeal 39 of 2025.
That is the interlocutory application, first.
In interlocutory application,
Interlocutory application
39
39
of 2025,
along with.
along with the criminal appeal jail number 12 of 2025, full stop. By the order dated 11/2/2026, this court, taking into account the medical condition of the petitioner, had allowed the applicant to be released on bail to enable him to undergo laparoscopic surgery. Stop. The order dated 11/2/2026 had directed the petitioner to surrender before the concerned jail authorities on the 31st day after his release for further incarceration. It was also provided that the sentence imposed upon the applicant by the judgment impugned in the criminal appeal would remain suspended for a period of 30 days to be counted with effect from the date of his release from jail. On expiry of the aforesaid period by the order dated 11/3/2026 passed in IA criminal number 13 of 2026, this court had extended the bail granted by order dated 11/2/2026 by another 60 days, and the applicant was required to surrender before the jail days on completion of 60 days from 11/3/2026. The present IA within bracket criminal 22 of 2026 has been preferred by the applicant, praying that the privilege of bail granted to the applicant be extended for a further period on the ground that the petitioner has been advised by the consultant doctors to undergo the surgical procedure after another month. Full stop. The learned counsel for the applicant has submitted that the privilege granted to the petitioner on the earlier occasion by the order dated 11/3/2026 expires today, that is on 14/5/2026, but the applicant could not undergo the surgical procedure in the meantime, since he has been advised for a further
Course of mitigation.
course of medication for optimization before surgery. Good stuff. The learned counsel for the petitioner has placed before this court a certificate issued by the Christian Institute of Health Sciences and Research, issued today, which demonstrates that the petitioner is being planned for surgery after a month and is currently undergoing medications for optimization before surgery. The learned APP has submitted that the petitioner has been granted the privilege of a bail for more than 3 months now, and there is no requirement of further extending such privilege when the proposed surgical procedure is not being undergone by the petitioner. We have considered the submissions made by the learned counsel for the parties and produced the certificate produced before us. The facts and circumstances, we have the considered opinion that the privilege of bail granted to the petitioner by the order dated 11/3/20, privilege of bail granted to the petitioner by the order dated 11/2/2026, which was extended by the later order dated 11/3/2026, can be extended for a further period of what is it?
May I complete the 45 days, because after 30 days.
For a period of 45 days from today, allowing the petitioner to undergo the medications for optimization of surgery and also to undergo the surgery.
That will be covered with this. Not like a surgery together.
Full stop. The petitioner shall report before the
With jail?
surrender before the jail authorities on completion of 45 days from today. Stop. I will accordingly disposed of. The certificate produced by the learned counsel for the petitioner is kept on record
Marked with it.
and marked as X.
For hearing item number 10.
Just
I do it put criminal appeal. No, the Lucia is that did you know?
in the criminal appeal. In the criminal appeal.
Restrict to expedite.
By the order dated 11/2/2026. By an order dated 11/2/2026, the registry was required to prepare the paper book. By another order dated 11/3/2026, it was observed that the preparation of the paper book was still under process. Today, we are informed that the paper book has not been prepared as of yet. Full stop.
How long will it take?
Appellant's list you have received late. Yeah. It was received on 5/3/2026.
5/3.
March. Okay, no, we are not going to say. Accordingly, list this matter again after 2 weeks.
3 weeks.
After 3 weeks, along with the paper book.
Yep, usual. Election. Election, yeah, you do investment, but qualified. Appellant, petition, appellant, we thought of the challenge. I don't know, indigenous. This application is filed by Ministry number 2. Petition to against that. Yes, Mr. Samir.
Yeah, pleasure, Lord.
What is the limitation for filing an 15 days from the date of the declaration of the, where do you get it? It's a notification?
NC Act.
Just give me the answer. 2003, 23, sorry, 2023. Section?
45, reading from section 45. Disputes regarding elections, section 25. At page 21. The requirements of the election petition also prescribed.
The Representation of People's Act has not been incorporated here. Give me the constitution. So this is the law. Jamir,
Yeah, pleasure, Lord.
what is your grievance in the appeal now?
Grievance is arising out of the IA.
Hmm.
Otherwise, main petition is pending before the tribunal.
Go before the, no,
That is what.
the petition is
what
pending
I'm
also,
trying to do.
the petition is pending before the single judge also.
Yes.
Hmm.
So that should be disposed of first and then let the tribunal decide.
That's
At the
different,
earliest.
but
It
what,
is an election matter
no, no,
which can be disposed of within the time frame.
no.
Otherwise, object of filing the application rather than.
You are aggrieved by the order dated 26/2025.
Yes,
What is the issue here? There is nothing. You wanted to withdraw,
yes,
right? You wanted to withdraw. This court said, okay, go there, withdraw, give the order.
yes.
You went there and additional prayer was made that the High Court has permitted you to
No,
withdraw to, that's
that
what
is a misconception. No. That is how I'm here before this honorable court.
Come,
Kindly come to paragraph 38, page 38. Page 38.
Yes.
This is the application, paragraph 5.
Hmm.
Page, internal page 3, page 38. That the applicant makes to state that the applicant has obtained the liberty to withdraw this instant election petition from the Honorable Gauhati High Court, Kohima Beach, and the Proceed Court has permitted the same. That is for withdrawal. Thus, the applicant may be given liberty to withdraw the said election petition with the liberty to file afresh.
Mr.
So,
Jamil,
the-
see, this court never gave you any liberty.
Yes,
Never give you.
but liberty to withdraw was given.
No, show me.
So I wanted to withdraw.
Show me that order.
6/6/2025, page 34. Oh, sorry,
33.
16. Just a minute. Page 50.
This is
Order
only.
starts from page 51.
Huh.
Contemplating to withdraw the election petition which is filed before the election tribunal, municipal and town council Nagaland, and therefore seeks for a week's time to place the withdrawal order before this honorable court.
So this is only to your prayer that,
Yes.
okay, give me a week's time. That was accepted.
Yes, thereafter, I file an application before a tribunal.
And that is that clause
And then
5.
tribunals fix the matter on 16. On 16/6/2025,
Allowed.
orders were passed. First order was modified by the subsequent order.
Same day.
Yes.
Hmm.
After 2 days, the matter was placed before the honorable court.
Page 34.
Meantime, they have filed a IA.
No. Here you see this order at 34. The applicant petitioners are at liberty, are given the liberty. The second paragraph, by which the honorable court was pleased to allow them to withdraw the election petition filed before this court. This court has got no jurisdiction to give you that. Then, in view of the order so and so, the applicants are given liberty to withdraw the election petition number with liberty to file appeal.
Yes.
How can he give the liberty?
So,
Because you have a limitation of 15 days.
was to withdraw and we will file an application before the tribunal. Tribunal will decide.
Where is that application?
Page 38.
Okay.
Page 46, I think.
No.
This application is before the tribunal. And these are the statements we have made. And by filing IA, the applicant came before this honorable court that we have misled this honorable court. In what manner, in what way we have misled, let them show. But this is our application. This is exactly what this honorable court has passed the order. And we have filed the application accordingly before the tribunal. Now the tribunal will decide whether I should be allowed to withdraw or not. To that application, the short time to file objection. And up to 2 days, the matter was listed before this honorable court. They have filed an application saying that we have misled the court.
Okay, that is something what is the error in this order dated 26? No, nothing. The court passed an order, it withdrew it. Now the matter is pending. There you go before the court and sort out the
No.
matter.
The wrong is this honorable court. When we sought liberty before this honorable court to approach the tribunal to withdraw the case.
Mr.
an
Jamir,
application has been filed.
that is not there. It's only a submission that you are withdrawing. Give me a week's time to place that order. There was no direction from this court, no liberty granted. It was only your prayer was accepted. So if that
Because whether to withdraw or not, whether to allow or not, that will be decided by the tribunal.
It cannot, because on that day, while you were granted liberty, the proceedings, that stay that was there, that was continued with. The tribunal could not have touched the matter. So now tell me, we are concerned with page 43. What is the error?
Yes. I am reading from the third paragraph. Today, when the matter is listed, no withdrawal order has been placed before this honorable court, and therefore, The result application seeking to recall the order dated 6/6/2025 passed by this Honorable Court in the main writ petition and to hear the case on merit. I, Amgen Learned Counsel, submits that he may be allowed to file affidavit to the application. This court, however, feels that no prejudice will be caused to the opposite party by disallowing the opposite party to file the affidavit and to hear the case on merit. In that view of the matter, the order dated 6/6/2025 passed by this court in the main writ petition is recalled and the petition shall be heard and merit. So why we have not furnished the order on this 20th June 2025 is that on 18, the tribunal has passed an order.
Withdrawing 16.
No. On 18, another order was passed allowing the applicant to file objection to that or withdrawal application.
There was also an order passed on that day, withdrawing the earlier order dated 18/5.
Yes.
Page 45.
Yes.
Come to page 45.
Yes.
So, the order dated 16/6/2025 is retracted herewith. So that order goes. So now the matter is pending, but there is a stay order of the writ court operating. So the tribunal cannot touch that matter. So the only way is you withdraw this appeal. You request the learned single judge to take up the matter at the earliest on merits and decide the issue. Well, why keep this pending? Mr. C.T. Jamil, learned senior counsel, assisted by Mr. I. Imchet, learned counsel for the appellant. Also heard Mr. A. Zimomi, learned counsel appearing for the respondent number 2, and Mr. Swanza, learned additional advocate general, appearing for the state respondents. Mr. Zamir, after attempting to argue the matter at some length, has submitted that he be permitted to withdraw the present appeal with liberty to approach the writ court with a request for expeditious consideration of the writ petition being WPC number 71 of 2025. So, on a consideration of the submission made by the learned senior counsel for the petitioner, which is also not objected to by the learned counsel for the respondents, we are of the view that the present writ petition, we accept such submissions made by the learned counsel for the petitioner, senior counsel for the petitioner. Accordingly, the present writ appeal stands dismissed on withdrawal with liberty to the appellant to approach with liberty as prayed for. Now the scenario changes to the single bench. But one thing, Mr. Jamil, just for mine, now we permit you to withdraw that writ petition, so that election petition. Will it be permissible to refile them?
Let them decide.
No. That is an issue we can't leave it because this is not a tribunal. It's an IS officer, basically. So it's not that he's not competent, he's competent, but this is an issue of law. When there is a limitation prescribed, 15 days, you cannot. And these are strict matters. These are election matters should be very strict.
Yes, I understand.
Think over it. In view of the order passed today, in the writ appeal number 19 of 2025, no further order is called for in the present interlocutory application, and accordingly the same stands closed. IAC 135/2025 day.
For hearing item number 11.
Initially, will not have. But in the final order, page 336. Mr. Jamir, where is the complaint petition submitted by the, before the Upa
Yes. Clear. 280. In the next page, in the second paragraph, doctor will find. We the undersigned on behalf of the aggrieved party. So they themselves are coming with a grievance, aggrieved. And can they come to page 284? Similar complaint has been lodged before the law like that. 284, paragraph 4 will be very clear that they are aggrieved. The nature of grievance should be specifically mentioned. If insincerity, similar complaint by all. So it speaks for itself.
Any further submission?
Another submission, Lordship, which will shock the conscience with due respect, Lordship. Can they come to page 340? There are two paragraphs here.
I think you will have to, before that, to shake the conscience, you'll have to go to 337.
340. In the first paragraph, 5 lines from the bottom. In the fifth paragraph, in the first paragraph, the court refrains. As your Lordship, correct?
Yes, yes.
The court refrains from expressing any opinion on the merit as these matters are only under the scrutiny of the Upper Lokayukta as well as by the department by way of the departmental proceeding initiated against the petitioner and which departmental proceeding has not been presently assessed in the present proceeding. And then following paragraph 30. The allegations made against the petitioners are grave and serious, and it appears that department did not initiate any departmental proceeding with regard to the controversy at hand, namely, and then explains. Just above few lines, departmental proceeding has been initiated and it is pending. That is the finding. Below few lines, no departmental proceeding has not been challenged.
Mr. Jamil,
Then-
your basic challenge in the present proceeding or before the writ court would be
Correct.
that this is a grievance. If it is a grievance, section 9, pre-read with the schedule, this Upayalukayukta cannot consider that.
Yes.
They would project that this is basically an allegation.
Then
So it boils down to whether it's a grievance or an allegation.
yes.
If it's an allegation, a proceeding may be maintainable subject to the limitation.
Correct.
Now, the learned single judge in para 25,
Yes.
more particularly para 337, page 337, 1, 2,
Yes,
3, 4,
correct.
5, 6, 7, 8,
I
9, 10 line, 10th line, 337.
It is said that the complainants are agreed by the seniority given to the petitioner, which it is alleged that the petitioner was allowed to incorrectly supersede the complainants, including the respondent number 5 to 9. There is no explanation as to why the complaint was filed in the year 2020 when the allegations made against the petitioner is in respect of the officiating promotion given to the petitioner as principal in the year 2014, and this will be relevant again. The grievance of the petitioner being senior or wrongly given the benefit of seniority over the complainants, including the private respondents number 5 to 9, is also prima facie not open to reconsideration by the department or the Upayalukayukta in view of the said issue already decided in an earlier writ petition filed in WPC number 107K of 2012, decided on 4/9/2013. No material placed before this court by the parties before the court to suggest that this order has been reversed by higher court. Consequently, this order has attained finality. This also speaks for itself. No, I need not.
Yes, who is appearing for the private respondents? Mr. Consul, I did not get your name. Jamir. Mr. Jamir, the issue would not be whether a proceeding against the petitioner is to be done or not done. The issue before this court was whether a proceeding before the Upayalukayukta the Lukayukta was permissible to be taken forward. Now that would be within the realm of the Act, Section 9. Now, if it is a grievance, grievance is again defined. If it is a grievance, that proceeding will not be there. Now, in para 25, this learned single judge has arrived at a conclusion that this was a grievance. Then the subsequent part becomes odious. It cannot be. That is perverse then. What do you have to say?
Worship, in order to study that, whether my allegation is grievance or allegation, Worship, kindly refer to two documents.
No, I'll not refer because that is the conclusion already drawn.
My complaint is not only grievance. No. My complaint involves allegation of possessing.
It cannot be. The allegation that you have leveled is the superstition of you being superseded by the appellant. It boils down to that. We will not let the appellant go scot-free. Don't worry about it. We will work out something that he will be facing a proceeding. But we are concerned whether the jurisdiction was exercised rightly by the Upayalukayukta.
Yes. Currently, I did put it down. Worship, kindly see my contents.
Hmm.
Whether my blame is grievance or it involves allegation also.
You take us through that. That's the first question we asked Mr.
Before complaint, Rashid mechanic come to beach 96.
96.
of the April memo.
Yes.
By
There
this
is a
cir-
stay order operating. There is a stay order.
Yes.
Hmm.
This is the circular issued by the school development lordship.
No, where is your complaint? Those exercises, the
Based on
school
this
department,
circular, lordship, based on this circular,
Hmm.
all the principals
they submitted their documents.
submitted their base certificate under the
Mr. Counsel, we are not even for a moment approving that the petitioner has the requisite qualification. We are not approving. We are only concerned whether, because the action taken in the matter is in pursuance to the directions of the Lokayukta. We are only with regard to that. Where is your complaint?
lordship page 280. This complaint was accompanied by an affidavit under Form 1 lordship page 86, relevant parties page 286.
Now, who is the aggrieved party?
Where the complaint?
No, you say come to page 281, second paragraph. We, the undersigned, on behalf of the aggrieved party in this matter. So you are making this on behalf of somebody. You can't do that until and unless he is dead in terms of your act. One. Two, now come to the Form 1, 284. Serial number 4.
That copy is page 286.
Oh, or 284.
286 is that copy.
Type copy, okay, I said, we have not gone that old now. We can read. Serial number 4. Effect in seniority. So it's a grievance.
Bill number 3 is also a relevant lordship.
Serial?
3.
Huh.
Complaint pleaded in square for to be included. Submission of the base pay certificate.
Hmm.
That is the allegation. That grievance. And para 6 also.
No, that is the cause. The effect is your seniority was affected. You are people whose admittedly he has superseded you all because of the earlier decision of the school.
Yes.
Now you come to para, you have not filed an appeal here.
No.
Now you come to para 25. Just read it for yourself for a minute.
Of the judgment.
Of the judgment. Page 336. Relevant would be in page 337, 10th line.
Yes, ma'am.
Give me the act. Mr. You have the act with you. Have you read that? You kindly read para 25
Yes, sir.
for your needs. G. But he has settled invested as a consequence of Nagaland. Now you come to minor. So the conclusion of the learned single judge in para 25 is that this is a grievance. It will be hit by the second schedule, and the Lokayukta will not have jurisdiction to look into it. Thereafter, the learned single judge proceeds to look into the nature of the allegation, that his B.Ed degree is false, and then says, then it confers, subject to what you say, this court conferred jurisdiction upon the Lokayukta to proceed with the matter,
So
which
far,
this court could not have.
so far as the allegation is concerned.
No, it could not, because once it has held that this is a service grievance, it's a condition of service.
As per the act,
Hmm.
the Lokayukta has no jurisdiction to investigate any grievance.
Hmm.
That is the medicine, that is the civil law.
Hmm.
However, my submission is that my complaint involves allegation as well. Allegation of processing fixed, Lordship.
Okay, give me one example. Tomorrow the Lokayukta says that these are all wrong. What would be the consequence on your service? You will get back the seniority. He will go. You get back the seniority. That is your interest. And where is the allegation of corruption? That this was done with A, B, C, D in the department to get that.
My other submission is by going through my complaint, which is submitted, complaint submitted by respondent number 5.
See, your complaint has been looked into by this court, by the learned single judge. And this is the finding. You have not challenged this finding. If that be the finding, the subsequent finding cannot be.
But the learned single judge, Lordship, the jurisdiction of Lokayukta.
Hmm.
This is the method for me to judge, Lordship.
We have to do something. Then we say that it is about
Lordship have voted out for a 25 judgment. I'm referring to for a 30, the judgment also finally. See, the contains the finding of.
No, this we are conscious of this, and this is rightly said. The grievance.
1 minute. What paragraph is? The allegation made against the petitioner of brief, insidious, and appears project. This is the judgment of the single judge. The learned single judge also deal with the allegation made by the complainant. That's why I'm just mentioning that my complaint involves grievance as well as allegation.
That is not the allegation. Here, this says that because the department had not taken action, we will get the department to take action. We'll ask madam to now look into it.
To be very concerned one aspect. On the basis of the complaint lodged by us, the lawyer to have another investigation. And during the investigation, the B certificate issued by one of the university that is Concord was
Is forged.
now
totally
the
false.
appellant, the writ petitioner, will stop the investigation.
No. We are here on a question of law as to whether in the fact circumstances, the Act of 2017, the Lokayukta could have looked into it. See, this is not a case wherein you did not have a forum to express your grievance. You had a forum. That is the department itself. One. Two, it's a grievance because your seniority was affected. You are not a whistleblower. You're not a whistleblower. You're not somebody from the public having got nothing to do with the matter. That would have been a grievance. It would not have been a grievance. It would have been an allegation. You are a sufferer, victim, because your seniority, your service condition has been altered. You are asking for a relief to that extent also, rightly, directly or indirectly. Now, in this fact situation, the learned single judge came to a conclusion, no, this is a grievance. If this is a grievance, it has come to a further conclusion that the Lokayukta did not have jurisdiction. Then from para 30 onwards, it looks into the nature of the allegation. Allegation is a part of that grievance. It's not that there is only an allegation, there is no grievance. Do you get my point? It's a grievance based on an allegation. So now the learned single judge finds, rightly so, because illegality having come to its notice, this court cannot shut down its eyes. But the direction ought to have been to the department, not to the Lokayukta. We only want to now change that arrow from the Lokayukta to the department. That's all. What do you say about that? You want that this thing has to be investigated into. That will be investigated into by the department. We will give a time frame also for them. Yes, sir.
Also, I am a great follower of that question. And now, since the issue relates to jurisdiction of Lokayukta, Your Worship, my submission will not be adversarial, Your Worship. I just want to know my jurisdiction, to clarify my jurisdiction. Now, here, this is a case where Your Worship, there's an overlapping of, in the complaint, there's an overlapping of grievance and allegation, Your Worship. Now, in fact, not only Nagaland Lokayukta Act, in fact, almost all Lokayukta Act, even Assam Lokayukta Act, like 1985, has similar provision in motion. And if I'm not mistaken, I think state of Maharashtra is the first which was.
There is a decision to that effect from Bombay High Court.
Yes. Now, in case if there, in the complaint, if there's an overlapping of allegation and grievance, whether Lokayukta had jurisdiction, Your Worship, and we just
And so when you are facing that submission, we are here considering an order of a learned single judge, conclusions. There is already a conclusion on record in para 25 that in the fact circumstances of the case, the Lokayukta did not have a jurisdiction. There is already a conclusion.
But Your Worship, if a lawsuit may read the judgment as a whole, including that paragraph 13, which one?
Paragraph 30 is only noticing that the certificate of the certificates, educational certificates, were not verified by the, or verified, but no action was taken. This court had directed the Lokayukta to proceed in the matter. Yes, and Shudman Patel, yes.
Yes, this Vishwasrao Chandandu Patel, Your Worship, the portal is the petition number 3169.
Which paragraph you want us to?
Paragraph 17 and 18. Para 17. May I read out?
Yes.
the main contention raised before us as well as before the legislature was regarding the jurisdiction of locator to entertain the complaint filed by doctors and such. It is not necessary to make a detailed reference to the affront or allegations made in the complaint, since they are properly catalogued by the locator in paragraph 5 purpose for the such and such, which is as under. Dr. Gupta such and such has been called for interview for the post of the such and such in the government general hospitals at such and such, although he was not eligible or qualified for the post. 2. Response number 1 to 3 has issued GR number such and such by abusing their position as public servant in order to ensure selection of doctors such and such. 3. The certificate and testimonial produced by the complainant such were not considered and no marks were given to him. And 4. The certificate produced by such and such were however considered without proper evaluation and marks were given to him. Now, regarding the allegation made in the complaint, it can be said that the averment made in subpara 1, 3, and 4 might fall within the area of grievance. However, the averment made in subpara 2, that is the abuse position, about the abuse position by the public servant to favor the petitioner squarely fall within the scope of the term allegation as defined in such and such. So, the averment made is also covered by the definition of maladministration. Therefore, in any case, this is one of those cases where it can be said that the averment made in the complaint are overlapping and cover the area and field of allegation as well as grievance. Now, so far as now, I'll just take the worship to para 18. In our opinion, it's not necessary to decide any wider question in this litigation once it is held that the complaint file was overlapping. It is not possible for us to accept the contention of the learned counsel for the petitioner that averment in the complaint were distinct and separate. In our view, the averment made are interdependent. The language used in the averment made leave no doubt in our mind that it was the cumulative effect of acts and lapses on the part of the respondent, which is the basis of the present complaint. Therefore, the averment are overlapping and amounts to allegation as well as grievance. And therefore, it cannot be said that in view of taken by the locator that the said complaint does not part by. In this case, it is section 9, Your Lordship. So I'm just on the jurisdiction, Your Lordship.
Yes, yes.
So in case if there is overlapping of grievance and allegation with the complaint, Your Lordship, that will not attract section 9, 1A, read with second schedule. I'm just submitting on my on the jurisdiction.
Now, Mr. Counsel, for our understanding,
Lordship.
now you have referred to para 17. In para 17, the court also held that the allegations that are there at clause 1, 3, and 4, which pertains to the qualification and the qualification and merit of the person therein.
So that is grievance.
Grievance. The maladministration is at 2.
Is it?
And there is a specific allegation
Is it?
that 3, so no, 2.
Lordship.
2.
Lordship, sorry.
So there is a specific allegation that particular government servants, 1, 2, and 3, had issued this to favor thee. Now show me one averment in the complaint to that effect.
That would be so
280. Come to 282.
page 281, the motion, the second paragraph. We, the undersigned, on behalf of the aggrieved party in this matter, would like to bring to your knowledge the following anomalies found in his.
That is qua Mr. Jamil.
Yes.
Huh.
So this is my respectful submission. These anomalies, these are the allegations.
No, this is allegation qua 1, 3, and 4 in that judgment. This is allegation number 1, 3, and 4. Allegation number 2 is not there. You come to page 82, the prayer.
What means your, if I'm not mistaken, what your lordship means to say is that allegation can be made only by
Allegation, no. allegation can be made by them that the employee, the director, the deputy director, the secretary, they together ganged up and facilitated the appointment of the person as that. Now you come to the prayer, sir, because we want an opinion of yours on that also. Prayer at page 82. 282.
282. Yes. Now, this is allegation, this is grievance, seniority,
That's all.
seniority.
So whole thing is qua the person. There is no person of the department tangled in. Because if you see this, the respondents number 1, 2, 3 had issued so and so by abusing their position as public servants in order to ensure selection of Dr. Vishwas Chudaman Ravandal. So there is a specific allegation. That is allegation.
Your Lordship, as I've said,
Hmm.
I am not adversarial in this. I just want to make my jurisdiction clear. Supposing tomorrow some complaint comes like in similar nature, unless some officers are named, I cannot investigate. That is,
No, if there is a maladministration, because maladministration, I think, is also a
Your Lordship, may kindly read
If you can come to-
section 25 of the Act.
no,
Your
no. If
Lordship.
we can come to 2K. Maladministration means action taken or purported to have been taken or failed to have been taken where such action or failure is unreasonable, unjust, oppressive, improper, discriminatory, or with undue delay, negligence, so and so, so and so, so and so. Now, sir, the problem with us is if we go by your decision that you have placed, we can come to para 17 for a minute.
Yes.
Respondent 1 to 3 is named.
Now, just come to para 1 of that 17(1), that clause. Dr. Vishwas so and so has been called for interview for the post of so and so at Dulia, although he was not eligible or qualified for that post. So, the allegation qua the person has been held to be a grievance. Now, his connection with the departmental authorities and a particular action being taken has been held to be a maladministration. The same definition for that we have in our rules here.
Your Lordship, I just want to make my jurisdiction clear because as I've said,
No, this-
if Assam Lookout Act 1985 is similar to this.
Mr. Counsel, this question of jurisdiction will never get redressed or settled till the litigations are on. This is a thing which should never get.
Now, when I say in this level, unless someone is named.
So this allegation, I'm trying to, we are also trying to understand. In this allegation, if there was an allegation that this factor was known to the director, was known to the deputy director, was known to the secretary, but they ganged up and issued orders promoting him, taking the guise of the directions passed by this court, then that part would have become an allegation. It would have been an amalgamation.
So for the local to investigate this, for my this thing, I want to make my jurisdiction, how to access the jurisdiction. So there has to be two parties.
No,
That one, the
no,
officers, or
No.
the officials.
no. Party would be the beneficiary itself, but you will
But
also
there
have,
must be some other official.
because if you come to the definition, I think there was a definition of
Your
allegation is not defined.
Lordship, may kindly see your section 35.
35.
There. The whistleblowers act.
Whistleblowers Act is applicable and whistleblower has been defined also.
Yes.
Saw somewhere.
And in whistleblowers act, your Lordship.
Hmm.
This.
Yes.
Section.
Thank you. Thank you.
3D.
Thank you. Because this was the gap in the thought process that I had.
Yes, section 3,
Ah.
your worship will be in page 5.
Hmm.
Page presentation is at the bottom.
Hmm.
C, complainant, your worship has got it.
Hmm.
Complainant means any person who makes a complaint relating to disclosure under this act.
Hmm.
Disclosure means
Means-
a complaint relating to, I'll be only on 2, willful misuse of power or willful misuse of discretion such and such. 3, attempt to commit commission of criminal offense by a public servant.
So 2 would be attracted here according to you.
And 3 also, this is a case of forgery.
Now come to the our act, section 2V. So whistleblower has been defined here.
Yes.
Means a person who provides factual information with prima facie evidence about corruption in a public authority, or is a witness or a victim in case of corruption before the loop. So if it is corruption in the fact situation, there has to be someone beyond that. Now my brother has found out something more. If you can come to page 284, 84. Now 2, serial number 2, name and address of the public servant complained against. It's only the appellant. So he by himself cannot be the person who is corrupted. He is the corrupter, if I may use those words. He is the corrupter. There is somebody who got corrupted. Where is he? Huh?
Name and address of complaint against.
Complaint against. So that complaint, if you have to bring in maladministration, there has to be a linkage with the departmental authorities. Or if it is a simple case of fraudulent documents, department is very much within its powers to initiate, and we will provide for that.
Sorry for taking time.
Oh, no, we are loving it.
To make my jurisdiction.
We are loving it. Mr. Counsel, what we are saying is what we are, our thought process is moving. It's not a final thing.
Well, this is meaning of corruption from Black Law Dictionary, Your Lordship. Corruption, Your Lordship has got it. Depravity, perversion, or can and impairment such and such. That is impairment of public official duties by bribery. 2, the act of doing something with an intent to give some advantage inconsistent with official duty and the right of others, fiduciary or officials used of a station or office of procures a benefit either personally or for someone else contrary to the right. Corruption in the office, official misconduct.
Mr. Counsel, subject to what you say, this corruption again, he is the beneficiary. He is the person who is doing the act. But there is somebody there.
But by misuse of
That misuse is not by him. He
What
is
did he misuse is the issue.
issue.
What did he misuse?
there is the fake BH certificate.
He gave the fake birth certificate. So that is on his part a misconduct,
Yes.
maybe an offense,
No,
whatever be appropriate forums to deal with it. Either the service law relating to the petitioner himself or the police on an FIR that a false document is going around. When you are making a complaint to the local authority, the misuse of power by someone who could have given him a benefit arising out of that certificate had to be in your complaint. You say he has used it. You do not say who is the person in the government or in the office who allowed that to happen or who allowed him to take an advantage. If that be so, against whom does the inquiry proceed with the locality? It cannot proceed against the person who produced the document because already there are avenues for a disciplinary proceeding or a police case. It does not include the locality. The officials who had allowed it to happen has to face the inquiry. There is no official indicator that these are the persons or these are the offices which have misused, which have misutilized, which have involved themselves in corruption, or which have tried to give that advantage to this particular person who got an advantage. If that is the case, then against whom does the look-after proceed? Cannot proceed against the man himself. And can the look-after say that, look, someone has told me that this man has a fraudulent document. Police, please find out where he has given all these documents. What benefit is it cannot be so wide. So particular officers to be named, the director gave you the benefit.
Lordship may just outline the jurisdiction, I'll go accordingly, that's all, Your Lordship.
The jurisdiction has to be understood in a case-to-case manner. You cannot have it.
The general-
It will be a jurisdiction.
Because the situation would come that wherein you have para 70.
Upon the wisdom of the local to find out, it will be the wisdom of the local to find out whether there is some authority which has been indicated to have misused or indulged in corruption. Then it can proceed even if there is an overlap. But if it is, this man has been given a benefit, who gave it? Where does he start?
He cannot take it on his own.
He cannot try to find out on his own that who might be the persons. Had there been one sentence in the complaint saying that the director or the department so and so office have allowed him to take the promotion, has given him the seniority, that is where the local could have proceeded to find out whether it was actually done. But here it is said he got a promotion.
Based on fake documents.
On the basis of a document, he has got a promotion. Please investigate. Can the investigation be done? The director, whether he is here or not. The one who gave you the promotion is gone. Then against whom is the company? It cannot be against the post itself. Corruption has to be by a particular individual, cannot be by a post. Therefore, unless it is indicated in the complaint that this man has misused it, this office has misused it, how can the local proceed? Is what I am trying to understand. No office has been indicated, no person has been indicated that this man did it. Please investigate. This man got a benefit. How does he investigate? Against people. I lost my car keys. I don't tell where, I don't tell when. How can it be traced? There will be no investigation. A simple GD entry report, we have information that he has lost his key. Is it not? I say I bumped into that man, he pushed me. I felt his hand in my pocket. He has taken my key. Now the police can investigate. So the mere stating the fact that he got a promotion. What is? He got a promotion because of this man. Then there is something to investigate. That is what we are trying to understand. Here, does it stop at the overlapping part? Or does it go to the extent where we do not know with what it is overlapping? With whom? The allegation is against whom? There has to be an allegation against someone. Reverse will be what I said. Allegation is what? If the allegation is only against this person that he has benefited out of it, the departmental inquiry or the police authorities would be enough.
My understanding, Your Lordship, was that since allegation was made against him, against someone for submitting fake certificate to this certificate, that itself is an allegation.
For that, again, the other part of the look at the saying that if there is an alternative forum where it could have been approached,
Don't come to me.
then don't come. So for that allegation that he has benefited, it is fake. To that extent, it is either the police or the department proceeding. One man knowing that it is fake has allowed it to go on. This man does not face a disciplinary proceeding as such, But why did you let it go on can be investigated by the local actor saying that for what reasons did you allow it to go? Then it could have been investigated.
Now,
That is
I just have your attention at page 338, para 27. Now, here the single judge has referred to section 8 of the Nagaland Lokaयुಕ್ta Act 2017 and says that even in spite of 9, power is still there in section 8. Sumoto power. But that sumoto power will again is circumscribed basing on a general and a specific approval given by the authorities mentioned therein. And the last authority is a public servant. If you can see section 8. Right? This is a public authority, a public servant. So that is very widely termed thing. Now, public servant has been defined in P, 2P. And the complainants are not public servants in terms of that definition.
Your worship,
Oh, sorry. It will be years old. Wait.
in your worship, there's no
No.
mention about public servant.
No. 281 E, any other public servant.
Yes.
So here, any other public servant, he is referring to clause 1 to E of 81.
Yes.
So that public servant, they cannot be deemed to be public servant. And it has not been brought on record.
If I'm not mistaken, your worship, I think it's 8.3, which the learners.
No, 81, page 27, para 27. Now, these investigations are by the Upalukayukta or the Lukayukta? Lukayukta. Upalukayukta. So, 8.3 will not come in. 8.3 again, there has to be an investigation by the Upalukayukta. Then the Lukayukta can take over. So, now if you come to the final conclusion, final direction, page 31. Sorry, page 341, para 31. 1, 2, 3, 4, 5, 6 lines from bottom of that paragraph. This court hopes that the Upalukayukta, while considering the matter in its entirety and disposing of us by a speaking order, will also examine the scope of passing of any such recommendations in view of the prescription under section 8 read with section 9.3. So 9.3 limitation. So 8, the jurisdiction is not there. Even 8 will not bring it in. Will not allow him to go scot-free. It will be an operation successful patient death case.
I just wanted to make my views.
Yes. No, we are also understanding. We are also learning from them.
As I said, your lordship. Because in Assam also similar provisions are there.
Madam, what do you have to say? Now you are the main. You are for the Department of Education.
Yes.
What do you say?
Please issue the show cause notice.
That is in pursuance to the
Yes, interim.
the push given to by you by the. We are interfering with subject to what we find.
Yes.
What we intend is that we will interfere with everything restore him back to the post where he was, giving you liberty to take a call basing on the materials within 15-20 days from the date we can pass the order. Take a call with regard to any misconduct being committed by him. If you find that there is a misconduct, to initiate proceedings under the Nagaland, what do you call it, rules of?
Nagaland Discipline and Appeal Rules 1967.
67. Within a time frame. And we will also provide that you are also at liberty to place him under suspension. That much we will do. That's why I said, operation successful, patient bill.
The very object of contribution of Lok Ayukta is to check corruption and maladministration committed by the person in office. Considering the explanation coming from the Honorable Court, I have been reminded to make this submission that my promotion, official promotion, was on the basis of an order passed by this Honorable Court in 2003.
That occasion because...
No, I'm coming to the relevant point. Complaint was lodged in 2020. Now,
6 years, beyond 9-3.
To challenge that order also, it was difficult for them, for the private respondents. So what did they? Maybe they have some connection. They have approached the Lok Ayukta. Lok Ayukta said, oh, there is a fine magic I can show. And then interim recommendation was sent.
Those
on the basis of interim recommendation, those
we'll not go into, sir.
And
thing is
about implication of section 9, clause 3, 1 and A and B. About with regard to the limitation, allocation 1 year. No, grievance 1 year, allocation 5 years.
Provided
Provided
that grievance is not hit by the second schedule.
Yes. And they try to connect these two, allocation and grievance. Lordship will find in page 47, there is an order of this Honorable Court, a division bench judgment. On the basis of the submission made by my learned friend while representing the Lok Ayukta, this order has been passed. Now, my learned friend should accept because he has not preferred any appeal. So, law has been settled that when there is a grievance, then Lok Ayukta do not have jurisdiction.
I, in a matter, forgot that I think I had dealt with, I think you were the counsel. Look at the matter. Therein I went that it is an allegation, so it can proceed. I think that's my conclusion. Madam, but such acts should not be left uncondoned. You will have to be very serious because this and his seniority being restored by this court will have got no connection with the fraud he has played.
Exactly.
Because that promotion automatically came. He then had a CMJ certificate, which is yet to be produced by Mr. Jamil. And then the second certificate is admittedly a false one.
Yes, exactly.
That is with us, but while we consider a matter, we'll have to consider the jurisdiction of the author. Now, hope and trust that you will do it.
Yes.
Or you can always come up.
In that matter, sufficient time may be given to us and say like between 6 months.
No, I'll give you 15 days to take a call.
No, I mean like to complete the whole.
No. The complete is up to you.
Oh, Lordship.
That is not 15 days to take a call.
Lordship.
And if you decide within a period of another 15 to 1 month to issue appropriate proceedings and also to place him under suspension.
Chief, let the discretion be left with the...
Everything will be left to you. Not me, I'm not passing any direction.
Because by expressing...
No, I only say that...
such expression, they will...
I only will say that we will only say that it's a liberty is up to them to institute proceedings, and such institution will also bring in, I think suspension is in 6 or 7. 6. Rule 6 also. We'll take care of that, don't worry. Save, yeah? Save. Sabka naam le lijiyega. Thank you. But thank you. It was a learning experience. Ten minutes, Sabka.
Just need the resume for you to speak. See, it's the problem. I get it. Oh, you go back, I need to work. Wait. What was?
One to eight. Part one na, part one na. Part one na.
Yes, yes, sir.
Also, I think to mention argument before. Here.
No affidavit has been filed.
No instruction. After, this is a very interesting case.
Land settlement. You are paying for the state response. Or the 3 week time to file an affidavit in the prayer is not objected to by the objecting. No, not objected to by the learners, the council appearing for the petition accordingly. Registered to immediately completion of 3 weeks. The respondents shall invariably bring in the court their statement. You have given 40%, why the another 60% is not giving? You got 40, 60 is in the bank. We'll see that if they delay it too much, we'll give you interest.
Yes.
Yes. That can be interest. We give him something. That's what. We say.
Also from the other party, Mr. Citizen, please make him listen on Monday for him.
Okay. On the prayer of Mr. So-and-so, an additional senior government advocate not objected to by the learned counsel for the petitioner, registry to list this matter again on 18. 18. What is his name? Where is made on behalf of Mr. Where accepted, restricted business. Yes. Yes. Why? Why? Why is it big? A prayer is made on behalf of Mr. Living the respondent number 8. The respondents. The respondent, others have filed. You have filed. Yes. Respondent number 8 containing record an affidavit. Bring on record 6 by way of filing an affidavit. It will become approved. A prayer is made on behalf of Mr. K.A. Rongmai for an adjournment in the matter on the ground that he is presently in bereavement. Prayer is not accordingly. 2 weeks. 2 weeks on a date to be fixed by. Yes. Yes. You're not a landowner here. Materials show that you are not a landowner. The respondent's appointment, how it took place, that we will look into. But you are not a landowner.
Lordship, I'm a proxy counsel.
Oh, you're a proxy
I'm a
counsel.
proxy counsel.
A prayer is made on behalf of Mr. T. Lordship.
I also have an instruction to, I also have some instruction. In the prayer portion, there is some mistake.
No, you do. You're not here a proxy counsel, so we'll not take further. Pungne for an adjournment in the matter on account of personal inconvenience, as well as to file a rejoinder to the affidavit filed by the respondents. Prayer accepted, registry to list this matter after 2 weeks. In the meanwhile, the parties to complete their pleadings. Yes.
Ladies Lordship, Lordship, I'd like to mention item number 15 on behalf of Learned Counsel Elif Rizal.
Lordship, may I please, Lordship, I'm from respondent number 1.
Yes, Mr. Ahmed.
Even in the last occasion also, Lordship, it was prayed that they will file the AO. So the matter has been fixed for hearing in the last occasion. It's been a long pending cases, Lordship.
Please, put the time to see.
This is
further
with
clarification from the
lease of
NC.
land. Lease of land that was cancelled. Right? Lease of land that was cancelled. Land belonging to the respondents. Then the
Lordship, we have given the land on lease to the central government, that is Project Seva. Lease got expired on 25/10/2012. And the land has been acquired. That is a different issue, Lordship. We are claiming arrear of rent.
that rate has been fixed by the deputy commissioner. They are aggrieved by that.
Lordship, they are challenging their order, Lordship.
Okay, we'll give them a last chance.
Fix a date, Lordship.
A prayer is made on behalf of Mr. E. Zhao, Learned Counsel for the petitioners for an adjournment in the matter on account of personal inconvenience to facilitate filing of a rejoinder. Also, time was earlier granted for the purpose. Time was, however, earlier granted for the purpose. As a last chance, registry is directed to list this matter again on 26 would be fine.
Lordship.
Or 28.
25th. That is Monday, Lord.
28. Let us have it on a Thursday. 28. 28/5/2026. For filing of rejoinder. Also, registry to list this matter. Registry to list this matter again on 28/5/2026. Rejoinder be filed on or before 26/5/2026.
Deeply obliged.
Yeah, please, Lordship. My lord, I beg to mention, I don't know about 14. But my lord, the last occasion, the state was directed to list the status report of the case. My lord, however, I have not received it.
But they have not filed your stay affidavit also.
Yes, Lordship. I need a few more days, Lordship.
On the prayer of the Learned Counsel for the parties, registry to list this matter again.
After 2 weeks from now.
On 29/5/2026. In the meanwhile, the petitioner shall file the affidavit envisaging service of notice upon the respondent number 3 and 4 by way of Dusty. First, the respondent shall also place on record the status report.
Lordship. Lordship, I'd like to mention item number 7. The affidavit is under preparation, so Lordship, if it can be granted, if I might do it.
Today I'm generous. All the this is water receiver.
Yes, Lordship. Lordship, my request is let this be the last chance, Lordship.
What is the system brought into place? Water receiver, you supply, you make money. This is the government, if it wants to have its own thing, what grievance do you carry?
Lordship, what has happened in this case is that, Lordship,
There was an agreement.
the agreement was there, Lordship.
That agreement is not with the government, with some authorities, whether they will be.
It's a jail authority, Lordship.
Ah,
It
jail
is government, Lordship.
Government means the governor.
Lordship, the agreement was entered with the jail authority. For that matter, in fact, Lordship, now what has happened in this case is that, Lordship, for the project, Lordship, no money was sanctioned by the government. So the petitioners incurred out-of-pocket expenses, Lordship, which was back in 2012, Lordship. He spent more than 20 lakhs approx.
And for the last so many years, you have been selling water?
It's a meager amount, Lordship. It's a
Okay.
meager amount.
On the prayer of the learned government advocate, the learned government advocate prays that she be granted further 2 weeks' time to file an affidavit in the matter, to file an affidavit on behalf of the respondents represented by. So, prayer accepted. Registry to list this matter again on 2/6/2026. So, the affidavit on behalf of the respondents will be invariably brought on record on or before 28/5/2026. The earlier case, I think I gave 28 somewhere, na, madam? One case?
29.
29. Yes. 28 I have not given.
No.
Okay.
Lordship.
Hmm.
Lordship, I beg to mention item number 10. Lordship, we have received your affidavit in opposition this morning. So kindly give us 3 weeks to go through it and.
What's your name?
Yakasumi, Lordship.
Akasumi, learned counsel for the petitioner, submits that an affidavit on behalf of the affidavit has been filed on behalf of the state respondents. Accordingly, today, accordingly, he prays that he be granted further 2 weeks' time to file a rejoinder thereto, if so advised. Also, prayer accepted. Registry to list this matter after 2 weeks on a date to be fixed by. Compassionate appointment, the earlier better. Yes, ma'am.
My pleasure, Lordship. Lordship, I beg to mention.
Oh, you all don't want me to sit in the second half.
She I did receive instructions.
Which one? Item.
Item 2 of Lordship.
Regularization 30 years.
Lordship, can you grant 3 weeks time to file affidavits? And get
Same thing, huh? 3 weeks time. Same prayer, 3 weeks time. Yes.
My apology for the indulgence, Lordship. In item 7, there's an intent, Lordship.
Interim order passed earlier to continue
Item
till the
7.
next date of listing. Item number 7.
Obliged, Lordship.
My pleasure, Lordship. Lordship, I beg to mention item number 13. Received instructions, so.
Same prayer, same as in 12, huh? Done.
I will pledge.
Thank you, Lordships. I beg to mention item number 17. This item in WPC 296 of 2023, petitioner would like to withdraw from the case. That may be permitted, Lordships.
No, there is only one petitioner.
Yes,
Show me you want to withdraw this case?
yes, Your Lordship.
296.
296.
What's your name?
Zakato Chishi.
I think 17, 18 are analogous.
17 and 18 are.
I'm going to petition item number 18. But yes, if they're referring to a petition, my prayer in item number 18, probably because.
Item number 17. No? Mr. Z. Chick, learned counsel for the petitioner, on instruction submits that the petitioner desires not to press the matter any further, and accordingly he prays that he be permitted to withdraw the present petition. Prayer is not objected to by the learned counsel for the respondents. Also, accordingly, in view of the submissions made by the learned counsel for the petitioner, the present petition stands dismissed on withdrawal. You write in item number 18. The registry, as prayed for by the learned counsel for the parties, the registry to list this matter again on 19/5/2026.
Item number 14.
14.
Yes.
Interim order passed earlier to continue till the next date of listing.
Lordship, I beg to mention item number 12. I have in Lordship.
11.
Yeah, I'm for the respondent for, and we are yet to receive instruction.
Why?
From the government.
Why?
Lordship,
Lady is before this court. You have not paid money. 2005, the father had died. 21 years have passed by. Why this is not being?
Lordship, we are yet.
We will see. We'll let the matter be called up. Yes.
For admission, item number 1.
Madam, they have said that you have already been put in the list.
Chief, about that, we have instruction from the client to file a reply to your commission. And I'm appearing on behalf of the lead counsel.
For the 2 weeks time is granted to the petitioner to file a rejoinder in the matter. No further adjournment shall be granted in the matter. Registry to list this matter immediately after 2 weeks from today.
Much obliged, Your Lordship.
For admission, item number 5.
Madam, what is this being done? These are poor people. You take up the Aadhaar. Aadhaar came much after the service particular. She had joined her services.
Your Lordship, my order dated 17/3/26, I was directed to get certain instructions.
17.3. Okay, the learned judge is back again next week. The week thereafter, I'll put it on that. He's already applied his mind in this. Learning positive this. And this is not done. On the prayer of the learned council for the parties, the registry to list this matter again on 29/5/2026. Plus, so-and-so learned government advocate has placed on record the instructions received by her in pursuance to the queries raised by this court-wide order dated 17/3/2026. The same is kept on record and marked as X for the purpose of identification. No, we'll finish it up. There's only 1 or 2 people. I'll pay their lunch today.
For admission, item number 11.
Yes, who is for the petitioner? Who is for the government? Somebody made a mention now. Item number 11. Madam, you are paying for the government?
No, Lordship, I'm for respondent number 4. I'm standing on behalf of my senior.
Respondent number 4, accountant general. Have you got the proposal, pension proposal? Have you got the pension proposal? Who is for the government?
This is for
Oh. Have you got the pension proposal? Pension proposal has not been sent till now.
No, Lordship.
Yes, you have not received the pension proposal, madam.
Lordship, can we grant us 2 weeks time?
No, 2 weeks is nothing. This lady is waiting for a long time.
We are yet to receive instruction, Lordship.
You are married? Sir, what is the position with regard to pension for unmarried daughters in the state? Is unmarried daughters entitled to pension for their life till their marriage? That much only. You don't give them till their date of marriage. You follow the central. Also, the learned counsel for the respondents shall, on the next date of listing, apprise this court with regard to the status of processing of the pension proposal of in regard to the services rendered by the deceased father of the petitioner, right? Also, raised it to list this matter again on 21. No. 21/5/2026. Get me the instruction what is happening, both government as well as the respondent number 4. Will not permit this to go on. Yes.
For admission, item number 8.
This was left out. Yes, have you got the instructions?
I received an instruction. Now the petitioner is in serial number 8. And 2 both have been reserved for the convention for this year.
Okay, but she'll not come in.
Serial number by this year, she will be in serial number 6. Lordship.
What do you say?
Worship, this may be as per the report, this matter may be disposed of.
What is your qualification?
I finished, right now I'm in class 11, Lordship.
Class 11. How old are you?
18 years, Lordship.
So you will be entitled only to a grade 4 post.
Lordship.
So this year, 2 vacancies.
Lordship.
Okay. Disposed of. Just take their names, son.
Yes.
Thank you.
Last question.
Anything more?
Yes. For admission, item number 20.
Yes. Okay, we do one thing. We come back at 2.
Yes.
Come back at 2.
Yes, my lord.
Yes.
My lord, this is the case where the constable was terminated following the disciplinary proceedings. Worship, I may just straight away go to my submission, worship. Our first submission, therefore, would be non-furnishing of the inquiry report. The inquiry report was never furnished to the petitioner before the disciplinary authority arrived at its findings. So in effect, this deprived the petitioner to really defend his case, and a reasonable opportunity to defend himself was as a result not afforded to him. That is my first motion. So here, I would like to place reliance on the series of judgments from Dear of Not, State of UP, with Muhammad Sharif, Kashina Dikshida, State of UP, and others versus Soros Kumar Sinha, and recently Manor will be very aware, Ram Progressing.
Yes.
Yes, my lord. My second submission would be the memorandum of charges. My lord, my submission is that the charge against the petitioner was for possession of 0.927 grams of brown sugar, worship. But the inquiry report and the perusal of the dismissal order would show that, worship, the charges were not proved against the.
But you have no pleading to that effect.
I have, in a way, Lordship, I have pleaded that it was the dismissal order is not a written order.
No, that cannot be, because you have not even pleaded anywhere and that this plea was never taken.
This, in connection with the memorandum of charges, and I have one additional submission also.
No, first you come to your this.
Yes, sir.
You have not taken a plea. Anyway, that is something which is evident.
Yes.
Hmm.
That would be my, that will be a part of my own submission.
Next.
On perusal of the inquiry report, which is annexure C of the affidavit in reply, my lord. It reflects that the statement of the witnesses were recorded one after the other. But on perusal, my lord, if I may just take my lord to annexure C of the affidavit in opposition filed by the state respondent's motion. Relevant portion, if my lord may refer to page 19 motion. Last portion motion. In the second hearing, all the witnesses were thoroughly examined one by one, and their statements were recorded accordingly in the presence of the delinquent 3947 ABC Namitushi. The statement of ASI was taken telephonically in the presence of the delinquent and the other witnesses and was also recorded accordingly. Here, my lord, their statements were made, but then on perusal of this inquiry report, it reflects that the witnesses which were examined by the disciplinary authority inquiry officer, cross-examination was not, and
Where have you taken that plea?
or should I have taken that plea? My lord, paragraph number 14, the rule 96 of the Nagaland Service Rule 967 is told that the government servant shall be given an opportunity to cross-examine the witnesses and give evidence in person. This is will extend my pleadings motion. That will be my second submission, my lord. And my third submission will be, my lord, if my lord may come to the show cause notice motion. Lord, on perusal, if we peruse this show cause notice, my lord, the predetermined mind of the disciplinary authority is manifested here. If I may just read the second paragraph motion. Whereas your own capability of lawful and efficient discharge of your duties has been impacted due to such consumption, use, and procurement, and whereas such acts have adversely affected the image of the department, and whereas these acts are criminal offenses as well as violations.
Where are you reading?
Lord, show cause notice, page number 18. The second.
No, this show cause is not the one. Now they have issued a memorandum. This was just a preliminary one.
Yes, this is I'm just trying to point out that there was, even before hearing the version of the petitioner and the show cause notice on perusal, if we peruse the show cause notice, my lord, the petitioner was not invited to make a defense of the show cause notice motion. The language.
Can you give me this Nagaland Service of Discipline and Appeal Rules?
My lord, I have it.
Yes, next.
My lord, with regard to the show cause notice, the show cause notice was in respect of substance abuse, whereas the memo of charges and the impugn dismissal order was of.
This is no, this is just an explanation for that will have no bearing. Now that they have issued a formal show cause, that will be one who will, page 23 would hold the field. Then, next.
Yes, my lord. Lord, my next submission would be that my next submission was that on 4th of July, on 4th of July 2023, a presenting officer was also appointed along with the inquiry officer.
Before the, along with the issuance of the show cause notice.
Along with the
memorandum
of charges.
So rule requires 9.2 memorandum of charges, 9.3 reply, 9.4 if not satisfied, the authority can proceed for an inquiry. So here your that predetermined mind concept would come in.
Yes,
that's what exactly I have written down.
That's what I want to point out here.
Done.
Yes.
Good. Then
now another aspect of the presenting officer memo. Here, if you produce the inquiry report, if we produce the inquiry report, the presenting officer was just a mere spectator. It is a established law that the inquiry officer cannot sit as a prosecutor and as a judge.
that material is lacking. Maybe, but the material is lacking. Okay, next.
Next, my lord, I just want to just on the point that proceeding was undertaken as a casual exercise, just to point out to this court that it cannot be done as a casual exercise. My lord, may kindly turn to the inquiry report motion. Page 21, relevant portion, and we just indicate one thing, motion. This might not be material, but just to point out, here at point number 4, the delinquent number such and such, being a member of a disciplined force, is bound to strictly adhere to the laid down rules of the force and maintain absolute integrity and devotion to duty. However, he acted in a manner unbecoming of a member of a disciplined force by actively involving himself in politics. There's no honor here. Thereby he has violated Rule 4, 1 subclause 1, 2, 3 of the Nagaland Government Servant Conduct Rules 1968.
Now you are on bail.
Yes, I'm on bail.
Then
my lord, just want to impress upon this honorable court that when a disciplinary proceeding is undertaken, it undertakes as the quasi-judicial authority worship. So, though of course the procedure strictly cannot be applied of the criminal procedure, however, due process has to be followed. That is my humble submission, and in that line, worship, this entire criminal proceedings,
But we are ready. Okay, we accept your prayer and we interfere. But the charges are very serious against you. You can't be left scot-free in this matter. So it's a fit case for a de novo inquiry if we reach that stage. Chances are serious because you have been involved in this trade, maybe for self-consumption, but you have been involved. You have been receiving materials from Dimapur, from someone. That's it. Yes, madam. If you have to rely on some judgment, just give him a copy.
Yes. If I may just supply my written gist of arguments.
Give the copies of the judgments also you want to rely. Because I will not have the... Oh, I can take it out. You've given the citations.
Yes, right.
Oh, then enough. That will...
Parent number also.
Oh, that is. Oh, give it to me, give it. Hmm.
Your Lordship, Rule 4 of the Nagaland Government Service Conduct Rules 1986.
Hmm.
Here it states that every government servant shall at all times maintain absolute integrity, maintain devotion to duty, and do nothing which is unbecoming of a government servant. So, Your Lordship, these conditions of services were violated by the petitioner by his very act of possessing 9.27 grams of brown sugar, which led to his arrest, Your Lordship.
So long ago, obviously.
So, Your Lordship, no illegality was committed in this dismissal. Moreover, during the preliminary hearing itself, which was conducted on 28/8/23, here itself, from the very beginning, the petitioner has admitted to the charges framed against it and has pleaded guilty also. Now, again, 3 consecutive hearings were heard. On all these hearings, the petitioner has clearly admitted to his guilt. On the second hearing which was conducted on 26/8/23. Here. Here also he has clearly stated that he had bought brown sugar from one parent for about 8 to 9 times, Your Lordship. And then he further states that on the evening of 1/7/23, while he was receiving the parcel from the sumo driver near the NMC complex, he was arrested by the police, Your Lordship. And again on 1/9/23, that is on the 3rd hearing, here also he has admitted to buying a brown sugar for his personal consumption, and here he pleads for lenient, Your Lordship. So, Your Lordship, there is no illegality in passing the detention dismissal order, Your Lordship.
Now, you have said that he has violated the conditions of the conduct rules. So that violation is qua the allegations leveled against him in this memorandum, right? So in the memorandum, the allegation that he has violated is qua the possession of 9.27 grams of suspected brown sugar. Now, first show me that this suspected brown sugar suspicion was elevated to a conclusion that it was brown sugar.
Yes.
Where do I get it? Was any FSL report brought on record? Correct. What is the citation of Saroj Kumar Sinha? State of UP versus Saroj Kumar Sinha. Kashinath, Dikshinath.
No, this is with regard to disciplinary proceedings should not be a casual exercise, and
What is that citation?
citation, Saroj Kumar is citation 2010 2 SEC 772.
2010.
2 SEC 772.
And Kashinath Dikshita.
Kashinath Dikshita will be Lordship 1986 3 SEC 229.
229.
Yes, Lordship, 229.
Muhammad Sharif 1982.
Yes, Lordship.
No. But Mr. Longkume,
Yes, Lordship.
you have the inquiry report on record now.
Yes, we have.
You can argue from there.
in the Tinoga tribe.
No, here today. Because SK Sharma is there. State Bank of Patiala versus SK Sharma. So you'll have to show your prejudice. One. Two, the conclusions are based on your own statements, wherein you have literally admitted to it.
To that, my lord, I just want to submit that admission cannot override statutory violation.
No. Once there is an admission, there need not have been any further inquiry. Inquiry is only to the extent where you don't admit. You have given the complete roadmap how the drugs is to reach you. Charge sheet also fine.
So, Lordship. Charge sheet was filed on 27/24.
Now, madam, when was the inquiry held?
Inquiry report was
So, when the inquiry was held, this was not there.
so, Lordship.
So, that charge is not proved. And you come to, madam, page 21. The inquiry officer will have to stick to the memorandum of charges. He can't go beyond that. Now, where are these charges against the petitioner that he has held to be proved? One, forget it's just a fact. Two, also forget. Now, three, the delinquent admitted to his involvement in the abuse of drugs. All three different occasions. So where is that charge against that you have been abusing? In the show memorandum of charge, there is no charge to that extent of drug abuse. And where is he involved in politics, madam?
Your Lordship, that must have been a
You had an occasion to file an affidavit. You have not clarified that. So by going high with the substance, he may have even gone and gave speeches on the roads. Maybe that's the thing. Anyway, but the Learned Counsel for the parties at length, hearing remains inconclusive. Registry to list this matter on Monday. I'll pass the order. Monday, I'll pass the order. Madam, we are interfering, but we will protect your right to proceed against him, considering the grievance nature of the charges, and he'll be under suspension for the period. Is he now addicted? No.
No,
Still addiction.
yeah, he's no more. He's no more abusing. That's my instruction.
Good.
Rehabilitated.
Rehabilitated. Hope he stays like that.
Lordship, just on a last note, I have given the citation. If the case of petitioner with regard to if at all minorities are available, can be considered in line with Diwali Kundu.
Backwages.
Yes.
Dipali Kundu would come in when I am satisfied that further inquiry is not required. But once Dipali Kundu would come in after the proceeding, subject to appeal, proceeding concluding.
Much better.
For admission, item number 21.
Your Lordship. And Your Lordship, we have received to whom it may be concerned certificate from the village council of the very village certifying that the petitioner was dependent on her deceased parents' religion. However, we have received it.
I'm sorry, ma'am, that is of no use. Anyway, on the prayer of the Learned Counsel for the petitioner, registry to list this matter again on 26/5/2026. You file, bring it on affidavit, we'll see. Bring it on affidavit, we'll see. And what about your brothers? All are not sister, brother, they are not.
Your Lordship, they are already married and I'm on this, we have 5 siblings, I'm in serial number 4, Your Lordship.
And what about, and how many siblings?
5 of us.
And what about the fifth one?
The 5th one is doing some missionary works, Your Lordship, in church,
And the first 3, all married.
all married.
Married doesn't make any difference. Married before your father's death or after the father's death?
Before Your Lordship. Your Lordship, I was the only one taking care of my parents during their prolonged illness.
No statement to that effect in your petition. Your taking care is your duty, but dependency is something else.
Lordship.
Try. Yes.
For orders, item numbers 22 and 23.
May I please, Your Lordship? Lordship, we have filed this I application, number 81 of 2026 for substitution of the petitioner, Your Lordship, on account of the petitioner's death on the 12th of January of this year, Your Lordship. Your Lordship,
This is beyond the minimum period prescribed. When was the death?
the death was on the 12th of January this year.
What do you say?
Your Lordship, seems I've just received the IA sometime in the beginning.
On the prayer of the Learned Council for the respondent. And for the Learned Council for the respondent, submit that they be granted time. Till.
Your Lordship, 3 weeks. maybe.
For small matters, 3 weeks, why? On, and this was done on 29/5/2026. For so.
May I please, Your Lordship? I have one request, Your Lordship, that we may be allowed to file our condemnation
That's up to you.
in the time. Yes.
That's up to you.
Yes. Most welcome.
Done. Finished.
Yes.